We're going to bring in right now special guest Twila Brase. She's the president and co-founder of Citizens Council for Health Freedom, and she's with us generally once a month as we talk about health care-related items. We're putting it into this program today because it's a part of our Money Mission Friday emphasis with William Parker as we talk about economic factors and things that are happening. But this particular issue affects economics, but a whole lot more. So with that, right in the midst of this, let me tell you about it. A 2-1 decision by judges in the federal Fifth Circuit Court of Appeals, a major decision that they came out with right on the same day that the impeachment vote in the House took place that specifically dealt with the individual mandate portion of the Obamacare Act. It's significant. It has very little been covered, and so we want to do that right now with Twila Brase. Twila, thanks for fitting this into your busy schedule.
Oh, I'm glad to be here. Thanks so much, Sam.
You issued a press release on behalf of Citizens Council for Health Freedom, which I have before me, in which you stated that your organization applauds the ruling. Then you went right after and said that it didn't go far enough. Tell us right now specifically, what was this ruling by the Fifth U.S. Circuit Court of Appeals in regard to the Obamacare mandate? What was good about it, and why didn't it go far enough, as you indicated?
So what was good about it is that it said that the individual mandate is unconstitutional and therefore cannot be enforced. And that's exactly what the lower court said as well. But the lower court went further, and they said that that judge, Justice O'Connor, said that because the individual mandate is unconstitutional, that makes the entire law invalid. That's what the lower court said. But this court, which is the appeals court, said we agree. The mandate is unconstitutional, but we're going to send it back to the lower court and have that court use a fine-tooth comb to go through this 2,700-page bill and figure out whether everything has to be ruled invalid or whether there are some parts of the law that can stay or lots of parts of the law that can stay. And they actually said that they're neutral on it, but they wanted to send it back. So it didn't invalidate the whole law, and so it's now going back to the lower court, which has already said that it was invalid. And so, you know, it's kind of funny. You might kind of wonder why, because that court has already said, because there's something unconstitutional in it, it invalidates the entire law. And the higher court's saying, well, maybe not. Go see if you can find something that changes your mind. But what it all does at the end of the day is it delays. It delays the decision, and it's likely to delay the final decision going up to the Supreme Court until after the 2020 election. In the meantime, of course, as I said in the press release, we were thrilled that the ruling quoted part of our amicus brief that was filed jointly with the Association of American Physicians and Surgeons. They quoted it in the very first paragraph, and we talked about the fact that the law is hurting patients. There's unaffordable deductibles, unaffordable premiums, unaffordable medical costs. You know, everything has gone up because of the so-called Affordable Care Act. And so we would have liked them to have ruled otherwise, but and sent it, and then it would have gone straight to the Supreme Court. But I think there might be some politics here in maybe delaying that so that it doesn't happen before the 2020 election.
Oh, you really believe there are politics involved with this, do you, Twila?
Well, the 2-1 decision is 2 Republican appointees versus a Democrat appointee, and the Democrat appointee wanted to say that the mandate is not unconstitutional. Just wanted to vacate, as it were, just eliminate, get rid of the first ruling altogether. And the two that ruled the day are the 2 Republican appointees, one by Trump, one appointed by Bush.
Sure.
So I don't know. It comes out the day of impeachment. That was interesting.
Yeah. Well, that is interesting, and there's no doubt. And, of course, you did say that it is going to hurt the patients. Let me ask the other side of that. Who does this ruling help?
It helps the health plans and everybody else who's making so much money off of the Affordable Care Act. It keeps them all in play. It helps the government. It does help any political appointees now who don't have to deal with it for the most part. So that's who it helps. And no, even if they would have, ruled it unconstitutional, the whole thing, kit and caboodle, right, it would have still gone to the Supreme Court. Now, it's very clear that the Democrats, who are the defendants, there's a bunch of states that joined as defendants. In other words, they want the law to stand, right? And they have said they're going to ask the Supreme Court to hear it right away. They want to bypass it going back to the lower court because I think they don't want that delay. They want that decision before the election. That's what I think. And I don't know what the Supreme Court will do when they're asked that question. So everything's a little bit in play, but even if they had ruled it unconstitutional today, it would not stop until it ended up in the Supreme Court.
See, that's interesting, Twila, because I think there were 16 states, if I read it properly, 16 states that were wanting it to continue, and then there were, I didn't actually add them all up, the others who were challenging and wanted it to be eliminated. So that being the case, when you look at it, what do you think are going to be the next steps? And what role, perhaps, is your organization, Citizens Council for Health Freedom, perhaps going to play in any next steps here?
Well, as far as our role, I'm uncertain whether or not we get to bring anything else to the lower court. If it goes to the Supreme Court, we would definitely be part of another brief and send that to the Supreme Court. As far as what's going to happen, I think it's going to be a matter of the lower court will take it and they'll begin. But then if the plaintiff attorneys, those states those liberal states, ask the Supreme Court, that's what's going to happen there. So there's going to be two things happening here. There is an interesting thing as well that I learned this morning, that in July, the Trump administration sent a memo to the appeals court, which has a very interesting little phrase in it. And they essentially said that they thought that lower court ruling saying that it was unconstitutional and that the entire law was invalid could legally be okay only for the plaintiffs. As in, so the plaintiff states, the Republicans, would be free from Obamacare and the Democrats would not.
Oh, really?
It was like, I saw it at the bottom of a news article, so I went into the decision, into the letter and went, really? They really did say that they thought that the court could rule that the Democrats could keep Obamacare and the Republicans could get rid of it.
Well, you know what? That presents a really interesting scenario, because if we, as free enterprise folks and folks who like patients to be in charge, if you got rid of the onerous parts, the Republican states, more or less those who say get this burden off of our back, they would be more free. And the Democrat states who want to be indebted to the federal control, they actually heap on themselves continued burden. It's almost like you reap what you sow type of a thing. That's odd.
Yeah, I thought that was kind of wild. I thought they really did that. It's only 2 lines in that letter, in that memo. And I thought, oh, wow, goodness. But clearly the appeals court didn't do that. And what the appeals court said to the lower court is that the administration has changed their position several times, and they have. And therefore, they want the lower court to consider all the changes in the administration's position and see if that would change the lower court's decision to rule the entire law invalid. And they say that they are neutral. That they are neutral about whether or not the whole thing should go away, the whole thing should stay. That's neutral, but at the end of the day, there's nothing in the Affordable Care Act that says, as many laws do, there's usually a little phrase that says, if any part of this is ruled unconstitutional, the rest, it will be severed from the entire law and the rest of the law will stand. That's called the severability clause. Yep. But the Affordable Care Act does not have that clause, which means that if you find something unconstitutional in it, then the entire law has to be ruled unconstitutional, or as a judge ruled it down in Texas, invalid.
I think that's a really great point. That severability clause, as you call it, is very, very key because precedent, I believe, would say just exactly what you said. I think that the court may have actually done more than what people are thinking about, because if Congress comes back and has to deal with the law, they're going to be bound by... Anyways, ladies and gentlemen, stay tuned on this. Twila, where can people go right now to find out more, perhaps on your website, about this or other things on this issue?
They can find our press release and some links at cchfreedom.org. cchfreedom.org.
All right. Twila Brase, President, co-founder of Citizens Council for Health Freedom. Thanks for filling us in on this very important issue. And stay tuned, ladies and gentlemen. Go to that website, cchfreedom.org, and find out more information about this.